look at the new standard contractual clauses that we mentioned at the beginning, because the next day after issuing the guidance on carrying out transfer impact assessments and supplemental measures, the European Commission published its proposals on new standard contractual clauses. There's a relatively short consultation period. It's actually already expired on the 10th of December. And as Ben's mentioned, the contractual clauses are probably the most commonly used method to authorize data transfers from the EEA. The attraction, at least until now, has been they're relatively easy to put in place, relatively cost effective. But the problem is that they're very out of date. The earliest ones date back to 2001. They refer to the old Data Protection Directive and haven't taken into account the GDPR. And practically speaking, people tend to just sign them and put them in a drawer. And so they don't really do a very convincing job in terms of protecting personal data. So it was always the intention to update the SCCs to reflect the GDPR. 2.5 years later, we're still using the old ones, but now we have proposed new ones, and they do have some interesting features to them. I'm just going to mention a couple of them now. First of all, whereas at the moment we have basically 3 sets of standard contractual clauses, 2 sets for controller to controller transfers and 1 set for controller to processor transfers, we now only have 1 set of standard contractual clauses, but they cater for various transfer scenarios. They cater for 4 different scenarios. So the controller to controller, controller to processor, but also processor to sub-processor, and the reverse transfer processor to controller. Those last 2 ones we don't currently have SCCs for, which can be problematic, but the new SCCs hopefully solve that problem. In respect of transfers by a controller to a processor, the new SCCs also meet the requirement in the GDPR under Article 28 for data processing provisions. So whereas at the moment you might have to supplement the standard clauses with additional data processing clauses, going forward that won't be necessary. But we do see one potential issue with that is, as many of us will have spent a lot of time negotiating liability limits and caps on liability in data processing agreements. The new SCCs say that each party is fully liable for any damage it causes as a result of its breach. Meanwhile, the SCCs also say that they will prevail over any conflicting clauses in any side agreements. So the question here is whether any liability caps that you've agreed in data processing agreements will be overridden by the standard contractual clauses, unless you can find a way to draft them in a way which is compatible with the standard contractual clauses. The fact that all this has come together, what I called at the beginning a perfect storm, is probably no accident, because they wanted to make sure that the standard contractual clauses that they introduce are compliant with the Schrems II decision and follow the guidance that's been issued, with a view hopefully to them not being vulnerable to further legal challenge, which of course is always possible. So the new standard contractual clauses do take into account the Schrems decision. For example, they have a provision that if the importer is subject to a legal requirement to disclose data to a government department, then they must first inform the data exporter where possible. And there's a commitment to exhaust all available remedies to challenge the request. So it's quite an onerous obligation on the part of the data importer to do that, to try and challenge any requirement from the local enforcement authority to gain access to the data. So what do we need to do given all of this is happening? Well, the new SCCs are not yet actually in final form. They may be subject to certain changes. Once they've been approved, which may or may not be before the end of this year, or it may be early in the new year, there's going to be a transition period of 12 months within which we have to replace all the existing old form standard contractual clauses with the new one. So it's going to require a lot of repapering of existing contracts. During this period, we can continue to rely on the existing SCCs, so for another 12 months or so. But we do have to nevertheless get on and start looking at the transfer impact assessments and supplemental measures in the meantime, because there was no transition period for that. And I can see a questions come on the Q&A about whether those things applied retrospectively. And I think if that's referring to the consequences of Schrems and the guidance on TIAs and supplemental provisions, then in a sense, yes, there was no transitional period for that, and that's immediately live, although there is going to be a transitional period for the standard contractual clauses. In practice, I think many organisations will take these things together.